Good morning. I'm Aaron Hall, an attorney for business owners and entrepreneurial companies. Before we get started, I want to tell you a little bit of a story. I was asked this week by a high school student whether I would recommend he consider becoming a lawyer. And what is it like? Is it a good life? What are the pros and cons? And I want to share with you what I have learned both in the process of deciding to become an attorney, as well as what it's been like as an attorney, so that hopefully, if you are considering being an attorney or you know somebody, a family member, or someone else, I'll present some considerations for you to think through in determining whether law is the right fit for you. Steve Jobs made famous the idea that you should do something you love. Because if you don't love it, the argument goes, how are you going to continue to do it for 10 years, 20 years, or 30 years? So choose something you love. And I think that can be really good advice for people who love something that you can make good money at. But a lot of young people, like this high schooler I was speaking to, doesn't know what he loves. He hasn't necessarily explored all sorts of things and areas and skills to figure out what you love. And there's an equally compelling argument, which is when you become great at something, you love it. So even if you may not have loved carpentry in the first few years, once you become a master, you often get a sense of satisfaction from that skill and being able to use that skill in a way others can't. So there's an equal argument, which is become a master at something, and then you will love it, and then you will enjoy doing it for years on end. So you can decide for yourself which of those two concepts are more persuasive to you or better align with your scenario. But I do think it makes a lot of practical sense to say, is there something you love now? And if so, what is it about that you might want to pursue further? Now, if you say, I love watching TikTok videos, I'd say, well, yeah, you also might love eating fudge or chocolate, but there may not be a actual job there. What we're looking for is something that you love to do that provides some degree of value to the world. And you also need to think about, even if you love it, is it actually something you want to do for the rest of your life? What does that type of career look like? For example, you might love acting, but that might mean you need to move to LA. Or you might love artistry and painting, but that might mean many years of not being able to earn a living until your paintings are well known. Or you might love producing music. And then you have to say to yourself, okay, well, what does that lifestyle look like? Somebody asked me about becoming a real estate agent recently, and or like a photographer. Well, both real estate agents and photographers work a lot of nights and weekends. Now, it's not absolutely necessary. There are commercial photographers who work during the day. There are commercial real estate agents who work during the day, weekdays. But a lot of real estate agents, especially those for residential homes, work when everyone else is off work because that's when they can go visit the homes. So I talked with this high schooler about what does the job of a lawyer look like on a daily basis. Before going to law school, I had the opportunity to talk with a lot of very successful and financially capable individuals because I did development and fundraising for a nonprofit. And I'd often ask them, what do you encourage your children to do? I thought, who better to ask than somebody who has children and has achieved some degree of professional accomplishment, enough to at least have excess money to give to a nonprofit. And I was very encouraged that by what they said. They said this: we don't try to uh, impose a particular career or choice or life on our children. Rather, we try to understand who they are, what their interests are, what they enjoy. And by doing various assessments of their strengths and interests and how they were made and their personality, you can often narrow down which career options would be the best fit. That might be strength finders or Enneagram, two very inexpensive ways to assess somebody's strengths and conversely their weaknesses. Another test to ask is, do you enjoy working more with your mouth, hands, or brain? In other words, hands would be a very physical job. Mouth would be like presentation, sales, or interacting and talking with other people. Brain would be strategic thinking, designing. Or do you like a combination? And if so, what does that combination ideally look like? You might say, hey, I want to work with my hands 90% of the day, but have some interaction with people as well. So some working with my mouth, some working with my brain. Or hey, I really enjoy working with my brain. I want to do that 70% of the time, but I also get energized by working with people and having that mouth component. And if possible, I'd love to use my hands. Now, a lot of jobs tend to be primarily one category: brain, hands, or mouth, and then have a secondary category with that third largely excluded. So that's one other test you can ask yourself. Here's another test. If you had to talk about one topic for every day for the rest of your life, what topic would you choose, or what topics would you consider? Maybe you'd say, oh, politics or philosophy or gardening or animals or fill in the blank, whatever that topic is. That can shed some light on the industries you might consider. Because even though you would bring a skill to the industry that involves your head, your hands, or your mouth, the topics that you're interacting with every day, it's nice to have something that you enjoy. Now, of course, that can change. And this goes all the way back to the original idea I talked about in the beginning. When you have a mastery in an area, you often have more interest in it because you feel proud of it. You feel proud of your skills. And so a lot of people have said in the middle of their life that they get great satisfaction and reward from doing something that they have developed mastery in, but they didn't like it in the beginning. So often we need to just pursue mastery and know that some level of satisfaction will come later. But I think at the beginning, it's always better to be intentional about our decisions and strategic and think through what does that lifestyle look like. Now, an attorney, uh, I know 1,000 different types of attorneys with entirely different lifestyles. For example, within private practice, which means you're practicing as an attorney working with clients, you have personal injury law firms, which are very similar to a traditional business. You have public advertising, you have internal management and processes and teammates that handle different parts. Whereas as a business attorney, you're working very directly one-on-one with each clients, and you have a relationship. And you're involved in business decisions as well as the legal decisions and the legal work. You can work as a corporate attorney, which is very much more like a business technician, and the technical skill set you have is as an attorney. You can use a law degree in all sorts of different other jobs. In fact, as I have interviewed CEOs and business owners, they will often put a law degree as more valuable than an MBA if they are hiring somebody for a non-law job. Now, I'll say that again. If a business owner or CEO is hiring somebody for a non-law job, so a business job, they more often than not consider a law degree as more valuable than a business degree like an MBA. And that's because law relates so much to business. And they also would tell you the having generic business education uh, is helpful, but you really need to learn a specific business to be good at a specific job. So that MBA may not be as relevant, whereas having the legal education and a law degree gives you a lot of additional value in a business because every business interacts with the law and is constrained by the law. One attorney told me before I attended law school that he would recommend law school because it helps you think like an attorney, but he would not recommend the practice of law because of the billable hour requirements, which basically means you need to work heavy hours. Yes, attorneys can get paid well, but that usually means they're working a lot of hours because they need to work hours serving clients so they generate revenue for the firm. But then they're also working on non-billable work like training of paralegals and legal assistants, administrative work, all the other work of running a business that is not actually serving the client and doing the billable work for the client. So, if somebody is considering becoming an attorney, hopefully the concepts I've presented here in a very quick fashion can give you some areas to dig into further so you can make an intentional and educated decision on whether the practice of law might be a good fit for you. All right, we are getting started with the questions for today. I'm Aaron Hall, an attorney for business owners and entrepreneurial companies. I'm taking your live questions first. I also have a number of questions that were submitted ahead of time, either on comments on other videos or elsewhere, which I will be covering. But first, your live questions will be coming up. Please keep in mind that what we're talking about today, this is an educational show. It's not a replacement for an attorney. An attorney provides a lot more value to you than a public educational show like this. The attorney takes the time to understand your goals and concerns. The attorney understands the law in your state, county, or jurisdiction. And the attorney can help you navigate the specific confidential issues that are not appropriate here. This is a general educational channel. So I invite you to ask questions, but please keep in mind, everything you post here is public. It sits on the internet forever, so please don't post anything that's confidential. I'm here running an educational show, not providing legal advice to you. That is for your attorney. You can use these topics we talk about today to identify issues to discuss with your attorney, but please don't rely on anything discussed here because I am not taking the time to understand the laws in your jurisdiction. We're not talking through all the exceptions that might be applicable to you. And there are many reasons why you are better served relying on your own attorney rather than a public educational voice available on the internet here. All right, let's jump into the first question. All right, Christopher Levinson, by the way, good morning from Los Angeles. Appreciate your comment here. All right, first question we have is from Vivian Figueroa, and I'm probably mispronouncing that, and I apologize. It's a fairly long question, but I'm going to read the whole question, and then I will summarize it in a shorter version and then talk through the issues. I have an LLC, which started as a home dessert shop, but I've created also a clothing business. But I have no change that second business to selling t-shirt designs, mugs, and a tumbler and other handmade products, also from home. I've been putting both businesses under the same LLC. Really, I really want to grow the dessert business. I'm just going to skim through some of this here. I think I think it's saying I really don't want to grow the dessert business, but I do want to concentrate on the art and crafts store. Is it better to change the LLC to the art and crafts store name or open a DBA? Some places give me a hard time accepting my LLC sales certificate for things being bought by the art store with a different name and um, let's see, both are new businesses. I have more expenses than sales, but I don't want to give up having a business from home. Is there a tax advantage for me to have two LLCs or one DBA and an LLC? All right, I think I would summarize it this way. If you have two businesses, should you have one LLC, two LLCs, or an LLC with a DBA? In fact, I think what she's really asking is two LLCs or an LLC with a DBA. When deciding whether to have two separate LLCs or an LLC with a DBA, the key question is whether you need separate liability between the two entities. I'll explain. First off, remember a DBA is just a nickname or an alias for an entity like an LLC. A DBA is not a separate business. It's just a nickname for the business. So if you don't need to separate liability between the two entities or between the two businesses, we'll call it, you can have an LLC with one name and a DBA for that same LLC with a different name. So that way, when customers see the different names, they don't get confused and they don't say, hey, why does my receipt have a different business name on it? It's like, no, we have a nickname, a DBA for this LLC, so people don't get confused about that. So an LLC with a separate DBA for a separate business is absolutely appropriate if you don't care about separating liability. What do I mean by that? Well, let's say one of the businesses gets sued. Because it's all in one LLC, both businesses are exposed to risk. And so if one business has bakery equipment and the other business has arts and craft equipment, both the equipment and the value of both businesses are exposed in that lawsuit. I've got some other videos where I talk about what you can do about that besides separating them into separate LLCs. One popular option is just get insurance to cover everything. So you would want a separate LLC if you want separate liability. So for example, if the bakery gets sued, the arts and craft equipment and inventory are not exposed because there are separate LLCs. In order to do that, you need to have separate bank accounts and you need to respect them as separate businesses. I have a separate video on piercing the veil, which talks about when one business can be liable for another and vice versa. That's called piercing the veil of limited liabilities between them, and a creditor or someone who sues you can pierce that and go after your other company if you don't do things right. So check out that video on piercing the veil to learn more about that topic. The other part of this question is there any tax benefit to having separate LLCs? The short answer is no, there is not, because the income and losses from these businesses will flow through to you, and you will pay the tax obligations once they flow through. The IRS calls this an ignored entity or a pass-through taxation, which basically just means everything from the business flows through to you. So there isn't a tax benefit in having two LLCs or an LLC and a DBA. From a tax standpoint, it's going to be neutral. All right, let's take a look at the next question here. This is a live question from the chat. Is it true that an LLC must register and pay filing fees in all 50 states? The assumption here is that if the LLC is selling online to people in all 50 states, does it need to register in all 50 states? You might say, well, what does the registration look like? Once you have an LLC, let's say you have an LLC in California. If you're doing business in New York and New Jersey and every other state, the states require that you register there. So the simple answer is yes. By law, if you are doing business in another state, you must register there. That's what the law of those states say. But practically speaking, that's expensive because not only do you have to register there, but usually you have to have a physical address where you can be served a lawsuit there. So now you're paying for a registered agent service. By the way, later after this goes live, we'll put in the comments section, or actually in the description section below, some additional YouTube videos I've done on this so you can get some more information. But the short answer is yes, by law, you're required to file in those 50 states. And then the second part of this question is, is it a one-time fee or do you have to keep doing it? In most states, you have to keep renewing it every year. That also means paying registered agent fees every year in all these states. Well, as you can imagine, this is extraordinarily expensive for a small little business. So what are you going to do about it? It's fine if you're Amazon. You can afford to have these registered agent offices and annual renewals in every state, but most businesses simply can't afford it. So what they often do is they either don't file to do business in any state except their own, where they already have the LLC registered, or they pick one or two states where they may have a lot of sales occurring. Well, you might say, well, what's the risk of not registering your business in 50 states? Because it sounds like I can't afford it. Here's the risk. If somebody who you sell to in a state where you haven't registered goes to sue you, you probably won't know about the lawsuit. Because if you're sued in, let's say, New York, and you don't have a registered office there, you don't have a registration with New York, under New York law, the person suing you can serve the notice on the government there, serve the summons and complaint. And there's a specific process in the statute that they have to follow. But there's a very reasonable chance you will never get a copy of these documents. And so you don't know about the lawsuit, which means you can't show up. And if you don't show up at that lawsuit, they win by default. It's called a default judgment. So now they have a judgment against you in New York. Let's say they sued you for $50,000 and the judge granted that. So now you have a $50,000 judgment against you in New York. What do they do with that? Well, they have a couple options. First, they can garnish and levy funds in a national bank. So if they go after like Huntington or Wells Fargo or one of these big national banks, they can levy your funds because they have an office in New York. New York judgment is applicable to a bank with an office in New York. Now they can freeze the funds in your bank account. Another option is they transfer that judgment to the state where you live. They docket it there. They get it filed there. And under the United States Constitution's full faith and credit clause, the judgment in New York is given full faith and credit in your state. So the courts must accept that judgment and docket it. Now they have a judgment in your state. Again, you may not even know about this, but now they can go freeze assets, lien them, levy them, garnish them, have a sheriff sale, whatever is allowed by state law in that state. So I've actually had this happen with clients. I at one time had a client who reached out to me and they said, hey, somebody just froze a lot of money in our bank account. And apparently it has to do with a Minnesota lawsuit from years ago, or from a long time ago. And sure enough, I looked and they had not registered in Minnesota, but they were doing business in Minnesota. They were sued in Minnesota. They didn't know about it. They didn't show up. They lost. That judgment came and they now froze money in the bank account. There is a process to try to undo these judgments, but in general, they're very difficult to do. And in this case, the court refused to undo the judgment. And so as a result, because this business did not register to do business in Minnesota, they owed a large amount of money to somebody who'd sued them. And they had a good argument for why they didn't owe the money. They potentially could have won the case, but it was too late. That is a worst case scenario. Practically speaking, most businesses only register to do business in the state where they have significant amounts of sales. You can also have an arbitration clause in there, which is requires that they serve you an arbitration. So that increases the odds that you are not going to get hit with a lawsuit in that state, because they are required under the contract to arbitrate with you instead of sue you. But the short answer is, are you required by law to register in any state where you have sales or business or employees or a presence? You absolutely are. Each state requires that. Okay, next question. This is a question that Jesse Haka posted on a YouTube comment. Can you cover the legalities and common legal challenges for a startup software company forming an LLC in California? This is probably a great moment to recommend that any business at least pay for 1 hour to consult with a business in your state. I'm sorry, to consult with a business attorney in your state to assess what specifically is required in your state to operate legally. You can probably do that for less than $1,000. And you will probably do it once in your life, because these laws don't change that often. Or maybe you'll do it every 10 years, but it's the benefit of getting educated by an attorney, understanding your circumstances and identifying what you need to do to legally operate in your state, in my mind, is worth the $1,000 or whatever it costs for that meeting with the attorney. Another option is to work with a CPA. In fact, this is my preferred option, or at least my first recommended option. The reason is a CPA also can be very knowledgeable about what needs to be done legally to operate. But a CPA is focused more on taxes and legal or financial compliance than all the other areas of law. But a CPA typically can help you figure out, do you need to collect sales tax? What sort of payroll tax filings do you need to do? CPA may not know as much about what's required for hiring employees. So if you're hiring employees, that might be something you'd bring in an attorney for. For example, a CPA would know what tax forms need to be filled out, but an attorney would know, by law, do you need to have an employee handbook? Are there certain policies or procedures you're required to have? I can tell you in all 50 states, you have to have something posted on the wall or in a spot where employees can see it regarding basic employee rights, regarding wages, as well as often regarding injuries. So I would recommend consulting with a CPA, and usually the CPA can save you thousands of dollars in learning what you can deduct on your taxes. So the CPA pays for herself or himself through that initial consultation, where you get a lot of good tips and advice. With that disclaimer aside, in order to operate a software company forming an LLC in California, at a minimum, you'll need to register your LLC in the state. You will have IRS and state tax reporting obligations. You will have data privacy requirements, so a data privacy policy and the various disclaimers that need to be provided both on your website for people who visit that, as well as some sort of provisions in a contract with clients or others you're engaging with. So I'm not sure if I'm answering your question about what are the legalities required for a startup company forming an LLC in California, but hopefully this has helped you identify some of the issues and figure out some of your next steps with meeting with professionals there. Okay, let's take a look at the next question here. All right. If I have, by the way, this is a message from a user who posted on a public comment on YouTube. The user's name is Paladin Hill. If I have a company registered with the North Carolina Secretary of State as ABC Services LLC, so that's a fake name, can I then have a DBA of Cheap Plumber LLC? In other words, may I include LLC in my DBA name, even though that name is just an alias? Thanks. So the question here is, can a DBA include LLC in the name? So you have an LLC that might be ABC Services LLC, and then you have a DBA, and you want that DBA to say Cheap Plumber LLC, not just Cheap Plumber. This is going to vary state by state, but in general, you can have LLC included in the name. So, but you need to check with your state DBA laws. And by the way, DBAs go by various names. Sometimes a DBA is called a fictitious name or an assumed name, or informally referred to as an alias or a nickname. But you'll want to figure out what is a DBA called in your state statutes, and then can you add LLC to the end of a DBA for an LLC? You might also wonder, can you add Corp or Inc. to the DBA of an LLC? And the answer is no. You generally cannot do that because the law requires that whatever term you use not be dishonest. In other words, you have to be honest about the type of entity it is. You can't put Inc., which stands for corporation, on an LLC. And you can't put LLC on a corporation. A corporation can typically be Inc. or incorporated or corporation, and there are a variety of other terms that are listed, usually in state statute, that are permissible for each entity type. All right, next question. This question's from Eddie Maddie, who posted it on YouTube. I own an S-Corp in Arizona, which I'm selling now, and buying a mobile home park in California. Wouldn't it be better to convert to LLC? And I can do that from Arizona S-Corp to California LLC. And do I need a new EIN? All right, so here's what we have. We have a business that's being sold in one or shutting down in one state. We have a business that's being started in another state. And the question is it permissible under law to use the same entity for both? And then also, is it a good idea? I'll just tell you, it's not a good idea. And it's usually not permissible because there are some legal problems. First, You can't go from LLC to corporation as an entity type. The only way to actually convert an LLC to a corporation is to create the corporation and then have them merge so the corporation swallows and engulfs the LLC or owns the shares or ownership of the LLC. So when you merge entities, you always have to decide which entity is being consumed and which entity is consuming or enveloping or swallowing the other. Which entity is going to survive and which entity is going to cease to exist or terminate. In a merger, that always happens. It's not an equal merger where now you have some new beautiful creation. It is one entity swallowing the other. So in order to have an LLC convert to an S Corp, although an LLC can elect with the IRS to be taxed as an S Corp, if the LLC actually wants to be a corporation, you must start a new corporation and have that corporation merge with and consume that LLC. So that's one issue here. The second issue is when an entity is built or is formed in one state, it exists there until it's closed. Now, if you can't transfer an entity usually to another state. You can operate it in another state, but the state where it's born is where it lives. And so what do you do? What do you do if you want to move it to another state? Well, you start an entity in that other state and it merges with and acquires and swallows the former entity, essentially acquiring all of its assets, perhaps all of its liabilities, its tax obligations, etc. But that's how you generally move an entity from one state to another. There's not actually a move process. It's an acquisition and a swallowing of of the old entity, and the surviving new entity is in the state where you now want to live for the future. So legally, in order to move entities between states, there has to be a new entity in that state and an acquisition and merger, if you will. Likewise, to convert from an LLC to a corporation, you need to have that process. But then there's the question of, well, what about using the original entity? Is there a reason you wouldn't want to? Yeah, the reason you don't want to is all the liabilities from your current or older business that you've been operating for a while. You'd like to have those come to a close. You don't want to have your new business typically on the hook for old lawsuits related to the old entity. So usually that's a very good time to just have a fresh start and let that old entity and any liabilities that might come up essentially just dissolve. The other question here was related to the DBA. Should you use a DBA? Like, let's say you decide, hey, I want to keep the old entity for some reason. Should you use a DBA? I just cannot see any reason why you would want to have the new business in California tied at all to the old business. For example, using a DBA to operate under the old business. If I were in this situation with the limited knowledge I have here, I would say if you're starting a new business in California and it's doing something different from a business in another state, start a fresh business there. Have the old business close, because then all of its liabilities eventually come to an end. Even though it's possible that creditors might sue the old business, once it's ceased operating and it has no assets in it, what's the worst that happens? They get a judgment against an entity that has no value. I suppose that's not technically the worst that happens. A creditor can also subpoena you as a former employee or officer or shareholder and do discovery on you. So you may have to respond to that discovery. But as long as you did everything right, and I'd say work with an attorney in your state to properly close that business, you're not going to have any personal liability for a business that closed. All right, next question is by Logan Hogan. At least that's the user's name. What can you do if you're sued by a party who is good friends with the judge? This is a paraphrase of Logan's question. Well, in most states, and certainly in Minnesota, you have a right to remove the judge from your case without any reason at all. Now, you have to do it right away, but you have a right to remove a judge for whatever reason you want. Now, you usually cannot just keep doing this to every judge, but you have a right to do that once and see who the next judge is that gets assigned to your case. Now, if you want to remove the second judge, usually you have to provide a reason for it. So if you're in a small town where somebody sues you and the person or the judge who's appointed to the case has some sort of connection. By the way, many times the judges will just remove themselves because they don't want the risk of getting a bad name or perception of corruption or something like that. But if the judge doesn't remove herself or himself, usually under state court rules, you can immediately file to have a judge removed. And by the way, you normally only have a few days to do this, so pay attention to the timelines in the state. If you get a second judge who you don't like for some reason, now you probably have to provide reasons for that judge being removed. And usually it's the judge herself who decides whether the removal is appropriate. So if you're sued by a party who's good friends with the judge, usually if you act quickly, you can file to have that judge removed without providing any reason whatsoever, and you have a legal right to have that filing be granted. That's usually the law in most states. Next question. Is it true you can't fight City Hall? You may have heard this phrase, and there's a perception out there that you can't beat City Hall. You can't fight City Hall. Is that true? And I think the question goes to, as an attorney who has worked with lawsuits involving cities and seeing what happens go behind the scenes, as I worked with a judge and as I've worked with a prosecutor's office, I've had extensive experience seeing what happens behind the scenes. And the real question here is it true you can't fight City Hall? Is it true that there is an unfair advantage for the government? And I think I'm going to say it's partly true, but it's partly not true. The perception is that because it's City Hall, judges are just going to give in because either they're corrupt, the judges are corrupt, or there's some sort of payoff, or there's some sort of city funds that are somehow going to benefit the judge, or the judge wants to be liked by city officials, or because the judge and the city officials occasionally cut some ribbons together or do politics together or attend parades together. For whatever reason, maybe just social pressure, there's a perception that the judge is going to be influenced to rule in favor of City Hall rather than give a fair hearing on the merits. I get that it's when you're outside, there's a perception that, hey, I bet people are weak. I bet that has some influence. But I will tell you this, I've never seen that aspect of influence on a judge ruling in favor of City Hall. But I'll tell you in a moment, I have seen another aspect. I've never actually seen a judge accepting any sort of money from the City Hall on the side, like a bribe or something like that. Why? Because that's just the consequences are huge, and the accountability for city finances within the city are fairly significant. And here's what I mean. Let's say the mayor wrote a check for something. You still have somebody in the city accounting department who's typically a lower paid worker who has to record that check and categorize it as what type of expense was this and for what purpose. There needs to be proper documentation on that. It needs to be reported to tax authorities. So it is very difficult for a person in any city government to get away with misappropriation of city funds because so many other people in the city have to have knowledge of the transaction. Now, I suppose in theory, if you had the mayor, the director of finance, and one of the accounting clerks in on the conspiracy, and then of course with the judge funneling some money out, in theory, that could go undetected for some time until an audit is done or somebody else happens across those transactions, or one of those people leaves their role and somebody new comes in and says, hey, what is this? But often those things would get found out. I've never actually seen a judge persuaded by that, by anything even close to that. Even social pressure. A lot of judges say they won't do things because they don't want to be perceived as buddy or friends or colleagues or associates with politicians and other people out there. Often judges go out of their way to avoid the perception that there's some sort of connection. Okay, so what have I seen? What have I seen where I think there's some merit to the argument that you can't fight City Hall? The city has significant financial resources. And when a homeowner is suing the city for something, the homeowner usually has limited resources. So you have a power differential here. Limited financial resources to hire attorneys and extraordinary financial resources to hire attorneys. So there is a significant power differential or financial differential here. And often more money can hire more lawyers who have more creative ideas and can more comprehensively argue and present written briefs in favor of a particular argument. So that's one power difference here. The second is there's actually built into law that states can decide when cities and state government can be sued and when they can't. There's an old idea in British law that since the king makes the laws, the king can change the laws, so the king can't break the laws. Because if the king did something that was illegal and said that was prohibited, the king can simply say, but it's permitted for me. So because you have this idea that the king can do no wrong, and the government is essentially the lawmaker, the law bender, or the law changer, the law interpreter, etc., there's this notion that came over into United States law that the king can do no wrong. But Congress and state legislatures looked at that and said, no, we don't agree with that entirely. We think that states should be able to decide when can a person sue government and win. So you have in every state, or if not every state, most states, a law that says when the government can be sued and when the government is liable. And usually it's a little higher standard than suing anyone else. So here again, we have a area of law where the government can't be sued. You have areas of law where the government can be sued, but there may be higher standards in place. So you need to look at your state laws to figure out when can you sue government. But as far as this idea of you can't beat City Hall, I think that because there are laws that limit lawsuits against the city, and because the city usually has substantially more money than an individual litigant, it is fair to say that you have, on average, an uphill battle if you are fighting City Hall in the court system. It's not because of corruption in the court. It's not because of back alley deals. It's because they have more money and the law generally favors cities, because ultimately, if you're suing cities and winning money, you're ultimately getting money from the taxpayers because that's where cities get their money. And so that's why the government did want to have some limits on when individuals can sue and recover from taxpayers. Is a lawsuit real, even if it's not filed? Before I went to law school, I thought every lawsuit has to be filed because we often talk about when lawsuits start as when was it filed? What is the filing date of the lawsuit? So I was shocked to find out that some lawsuits do not have to be filed to be real and exist and have uh, every form of life that another filed lawsuit would have. This is known in legal circles as pocket service, and it doesn't exist in every state, but states like Minnesota allow for the starting of a lawsuit prior to filing. I'm talking about in state court. Most courts require a lawsuit to be filed in order for it to start. And in fact, usually there's a second requirement, which is not only does the lawsuit have to be filed, it needs to be served on the other party, the defendant. And then the clock starts ticking. But Minnesota has a unique law, and there may be some other states that still have this, but I don't think it's many. And it's called pocket service. And basically, in Minnesota, you don't file a case first, you serve it on the other side. And then, once that document, that summons and complaint is served, the lawsuit has begun. Now, what's interesting is there's no public record of it. The courts don't know about it. Nobody can find out about it unless the two parties in the lawsuit tell somebody or file it in court. Now, the law says in Minnesota right now, you do have to file that lawsuit within 1 year. But for 1 year, that lawsuit can sit there privately. Why does Minnesota allow this? The idea behind it is that if parties want to settle and keep this matter private, why bother the court with it? Why involve the legal system and incur taxpayer costs and court attention when the parties can work something out? So in Minnesota, once a lawsuit is served, it starts. The lawsuit has begun. It has officially commenced. And the parties either can settle the case, and that settlement can be entirely private and never filed in the court, or the parties can file the case in the court, or if nothing happens within a year, the case by law is considered dismissed with prejudice, which basically means it can't be filed again. So if you commence a lawsuit in Minnesota and you don't file it within 1 year, your lawsuit is officially dismissed, even though no judges and no court has ever seen it. So is it possible to have a real lawsuit, actual litigation that's never been filed in a court? Yes, it is. It's possible in some states like Minnesota. And in fact, every Minnesota lawsuit typically starts with the service of a lawsuit, so the hand delivery of it on a person, without actually filing it in the court. It might be filed a week later, it might be filed months later, but the lawsuit begins upon service of process or service of the documents on the other party, not upon filing in Minnesota State Court. So yes, it is certainly possible for lawsuits to be not filed and still be real. Those lawsuits are confidential, and that is actually the typical way here in Minnesota. Next question from Keenus Lonely. Do you need to renew your DBA every year? In generally, yes. Once you set up a DBA, which is a fictitious name for your LLC or corporation, it's an alias, it's a nickname. You typically need to renew that every year because it is filed with the state, whichever state your business is in, so that everybody knows, or at least this is the theory, that everybody is on notice that you have an LLC or a corporation which also goes by whatever the DBA name is. DBA stands for doing business as. So the LLC can operate under its own name and do business as whatever fictitious name or assumed name you've made up. But yes, you generally have to renew that each year. If you don't, sometimes in the state, you are permitted to pay to have it essentially filed and resolved or backdated. Other times you lose it and you have to request that DBA again. By the way, if that happens to you, I recommend working with an attorney, especially if somebody else has filed for that DBA first, like if a competitor comes in to use it, because you may still have common law trademark rights to your DBA name, even if you temporarily forgot to renew it or register it. All right, next question. Do you need to file your DBA with the IRS? The IRS doesn't care about your DBA. The IRS cares about your entity and whether it is paying taxes. Now, usually the IRS forms have a spot to designate whether your business has a DBA or operates under another name. And you need to put that in there because IRS filings need to be accurate. But here's the important distinction. The DBA isn't filing taxes. Why? Because the DBA is a nickname. For example, my name is Aaron, but if people call me Bud, like let's say I grew up and I had a nickname Bud, do I need to file taxes as Bud as well as Aaron? No, I don't have to file taxes because I have other nicknames. I have to file taxes under my legal name. LLC and corporations are the same thing. They have to file taxes under their legal name. A DBA or an alias does not create a new duty to file a separate tax return. All of the money generated by the business, which happens to use nicknames or DBAs, is filed as that business. So the DBA money essentially is already included in the business. There's no reason for a DBA to file a separate tax return. All right, next question here. This is from Endorse God in You. Do you have to create a legal notice in a publication for a DBA? Oh, this is a hot topic and one that I get fairly frustrated over. The general rule historically before the internet was if you have a business doing business under another name, so a DBA, you filed that with the state, but then you also had to file a public notice in the official newspaper where public notices are published. And the idea there is, hey, the government knows about it, but if you want to let the public know, it needs to go in the official publication for that state or county. That made perfect sense before the internet. But now, if I want to find out if somebody is using a DBA, I don't go find my local library and look up the archives of the official announcements for the last few years looking for a DBA. That would take an enormous amount of time. And by the way, that's what law firms had to do if they didn't have some sort of electronic service. They had to go to the library and look up the old legal notices in newspapers and see what notices had been published. I actually had to do that because I ran into a situation where the public notice would have been before the internet. And so the question then is, was there actually a public notice done? Setting all that aside, today, it's so easy to look up a DBA on the state website that handles all the DBA registrations. So there's a question, why would I have to publish it in a legal newspaper as well? Legislators have said the same thing. And so legislators have brought legislation forward in various states trying to get rid of this requirement that you file a notice in a legal newspaper after setting up the DBA. And to my knowledge, in most states, you still are required to do that. So to answer your question, do you have to do it? The law says you do typically. You might say, why are legislators requiring business owners to pay these fees? Here's the rationale that legislators have told me. These little newspapers who publish all these notices basically have said, we'll go out of business if we don't have all these public notices. We rely on that to stay in business. And if you're going to get rid of the public notices required for LLCs, but you leave the public notice requirement for other parts of the law, like a sheriff's sale or things like that, then you're not going to have any newspapers available where you can publish this. Frankly, I'm not convinced by that argument because I think there could be a very low cost newspaper that is largely available online that could still handle all of the legal notices. But this is an issue for state legislatures. Nobody's asking me my opinion on it. Right now, until the state legislature eliminates the requirement that you do a public notice, legally, you're required to do a public notice in a newspaper before you are lawfully allowed to use your DBA. Now you might say, what happens if I don't? What happens if I file with the Secretary of State and I never do the public notice requirement? Well, in most cases, nobody's ever going to know. And if you get sued, the lawyer's just going to look you up, the DBA up in the Secretary of State's website. In theory, at least, hypothetically, if you didn't do the public notice, a lawyer could at least argue to a judge that you were using a DBA name that you were not legally authorized to do. So instead of that being part of your LLC, the DBA was a wrongful alias for you individually. So you should have personal liability. I've never seen that argument be successful. In fact, I've never even seen an attorney raise that issue. I haven't specifically researched it, but I tend to think judges who look at this situation are going to say, okay, I get the argument, but were you actually on notice like that the LLC was probably the one providing the services here? And usually anyone suing a DBA realizes there's a business behind it, and usually they know the business name. So I think it would be a pretty hard argument to win. So does this mean that business owners can avoid filing in an announcement in a public newspaper and just set up the DBA with their state government? Well, legally, you're not supposed to, so there still is some risk, but I do think it's a fairly low risk. And I am also aware that many businesses who have DBAs do not actually do the newspaper notice requirement. Next question from Nesh and Nay. If a judgment has the LLC name, but the DBA isn't listed in the judgment, does the judgment have to be revised? The answer is no. So here's the situation. There's a judgment against an LLC, but that LLC has a DBA. Is the judgment valid, or does the judgment issued by the court have to be revised so that it mentions the DBA as well? Well, I'll answer this by analogy. Let's say people called me Bud growing up. That's my nickname. That's my alias. But my real name is Aaron, and the judgment is against Aaron. Does the judgment need to say Aaron is also known as Bud? No, I can have 100 different nicknames. A judgment doesn't have to say that. In fact, the judgment needs to be against a legal entity or individual. And so the judgment should properly say whichever legal name is used for the LLC. And typically, DBAs are not listed in judgments, but it's up to the judge. The judge could say, hey, this is Aaron Hall, also known as Bud, or this is ABC Services LLC, also known as Joe's Plumbing. So if a judgment has the LLC name but not the DBA name, does the judgment have to be revised? No. Next question by Nesh and Nay. If a new owner buys a business and that business has a judgment against it, is the judgment still valid for the business, or is the judgment only for the prior owner? So I'll tell you how to get around this in a moment, but let me just first answer the question. A judgment on a business stays with that business. So if a new owner buys the business, the judgment remains with the business. So for example, let's say we have ABC Corporation and somebody sued ABC Corporation and they got a judgment for $100,000. And let's say you go buy ABC Corporation. Does the corporation still have that judgment against it and still owe that money? Yes, it does. There's no question about this. So how do you get around this? Because obviously you don't want to buy a business with a judgment. You can, instead of buying the stock of a corporation or the ownership of an LLC, don't buy the entity. Don't buy the LLC or corporation. Buy the assets out of it. So you're not going to buy the liabilities of it. Those are the debts of it. You only buy the assets. So let's say, for example, you have a piano store. They have 100 pianos for sale, and you want to buy that business. You want to buy the customer list so that you can stay in touch with all these piano buyers. You want to buy the inventory, so that's all the pianos. You may want to buy some other contracts. You might want to take over some of the contracts of the business with contractors. If that business has a judgment against it, don't buy the shares. Don't buy the business itself. Buy the pianos. That's the inventory. Buy the customer database. Buy any assets that you want out of the business, but don't buy the entity. Leave the liabilities in the old entity and start a new entity. This is really a great best practice for buyers of businesses, because even if you don't know about a judgment that's out there, there might be a lawsuit that comes later from an old business. So I always recommend my clients who are buying businesses buy the assets of the business, not the entity itself. You can even buy the name, so you can keep using the name. Basically, you let that old entity go, you create a new entity with a new name, and you authorize use of that new name. As long as this is done right, the old entity's liabilities will not transfer to the new entity. This is called an asset purchase as opposed to a stock purchase. A stock purchase is when you buy the stock of a corporation. An asset purchase is when you just buy the assets out of the corporation. You don't acquire the corporation. And those assets can be everything of value: the company name, the customer relationships, the inventory, cash and bank accounts. It can be whatever you want. The employees, the contractors. But what you're not buying is the liabilities, and you're not buying the shares. All right, let's take a look at the next question here. All right, so this is a long one. I'm going to read through this and then I'll summarize it here. Sella Graham asks, I am a serial entrepreneur. I, uh, I find that I'm working on 3 businesses. I'm currently a virtual tax preparer. I also have a mobile notary public business. So she's a notary public. I also have a large family. So since 1997, I've been doing party planning for my family and have always found it to be a sweet spot for me because it's very fun. And who doesn't love a celebration? These 3 businesses all currently work under my power, but my main LLC is seasonal and the mobile business is on demand and per diem, so per day. So per diem is Latin for per day. This new venture will be a separate space with the option to customize a party package that is dropped off and picked up after. I plan to have insurance cover the rental and party planning, but since the nature of the third business is bouncy house functions, I may need an LLC to handle the full liability of it. My only question is, if I continue with just a DBA on the rentals, am I able to get an EIN for the rental business? TIA, thank you in advance for your time and competence in this role. All right, so the big disclaimer aside, always consult with an attorney in your state. I'm just going to take this as a prompt to provide value to listeners and viewers who are trying to learn more about the law. What we have here are 3 businesses. And the question really comes down to, should I have a DBA or separate entities? And then how does the EIN work for that? So the general rule is if you're worried about lawsuits, have separate entities. But if you can mitigate the risk of lawsuits by having one insurance policy for all of them, you can have them together in one entity and just have little DBAs or nicknames for the different businesses you do. And then as far as the EIN, an EIN is just a tax ID for an entity. It's a way for the IRS to put a number to a business or person. The tax ID for individuals is our social security number. The tax ID for a business is an EIN. So the IRS is not really concerned about DBAs. What the IRS is concerned about is each tax-paying entity. That's an LLC, a corporation, or an individual, and whether they're filing tax returns and paying the taxes that are owed. So the EIN is just a convenience for the IRS to track your entity. So what would I do in this situation? Well, in light of the fact that this seems to be a lot of low-risk businesses, with the exception perhaps of the bouncy house, and probably low revenue businesses because it's one person running multiple businesses, I would probably just focus on having one LLC to keep it simple and have a good insurance policy that covers the potential of injuries on the bouncy house and covers any sort of errors that you might make as a notary public. But generally, notary publics don't get sued. And let's see, the other business types here. Party planners usually don't get sued. The bouncy house issue, that's a concern, but you can get insurance on that. You might say, well, why not just have 3 separate LLCs? Isn't that the safest? Isn't that the best way to avoid risk? It is. It is absolutely the best way to avoid risk. But it requires tracking 3 LLCs. So now you have lawyer fees and filing fees to set up each one of those. You have to have a separate bank account for each one of those. You have to have separate accounting for each one of those. They may have separate tax obligations, either for federal or state taxes. It just becomes confusing. And it's hard enough for business owners to be successful growing a company with a single entity. But when you add in all this additional complexity that requires your time for administrative work, and it it takes your attention for making decisions. I think that that time is far better spent making money for the business. That's why I would not recommend getting too complex with multiple LLCs unless they are generating a large amount of money, or if they had different pools of employees. So if you have a party planning business that's so busy that you have 5 employees, and you have a notary public business that is so busy that you have 8 notary publics out there. Okay, well, I think that you're probably making enough money now to have separate entities. Plus, you're probably going to want to track the finances separately anyway, so that you can make good business decisions, knowing which businesses are profitable and which businesses are having challenges. So once you get profitable, yeah, go ahead and spend a little bit more money on getting that organized and having liabilities separate. But if you are a sole individual running these businesses, doing most of the work for the businesses, I generally try to keep it as simple as possible and mitigate the risk through insurance policies that are specifically tailored for the risk that you think you may encounter. All right, we have another question. I won't read the username because it is not necessarily pronounceable. I have an LLC for my personal chef business, but I want to start a company where I do business ventures outside of culinary and food. Would it be better to start another LLC, or should I file a DBA with a more suitable name? All right, so we have a chef business, and the owner wants to start another business, perhaps multiple other businesses. The big question in whether to have multiple LLCs or not is, are you concerned about the limited liability? So if you are concerned that the businesses would have shared risk and liability, and you could lose one business and its assets from a lawsuit in another business, then that is the reason to have 2 separate entities. But most small businesses don't have a lot of value in the business. You don't have hundreds of thousands of dollars in equipment. You might have $5,000 in chef supplies because you have a chef culinary business. Well, the tools and equipment and the inventory that you may carry as a chef is pretty insignificant compared to the size of a lawsuit. So I wouldn't be as concerned about a lawsuit in your new businesses that affects the chef business. I would focus on get a really good insurance policy that covers the risks of all the businesses, have a single entity so that you keep things simple and you're spending as little time as possible with the administrative burden of multiple LLCs. And then get a DBA as needed for public relations purposes. DBAs are only for public relations. They're not for business purposes. So if you have a chef business and let's say a clown business where you are a clown and you go to parties, go ahead and get a DBA for the clowning business. But I would keep it simple in a single LLC, mitigate risk with insurance, and then wait to have multiple LLCs until you have either a lot of revenue coming in from both businesses, or a number of employees in each business, or significant assets, like over $100,000 in assets, like real estate or something like that. Though when you get to that size, significant employees, revenue, or assets, that's when it can make sense to hire the professionals to have those separate LLCs. But otherwise, I'd say keep it simple and get insurance to mitigate any risk of getting sued. Okay, let's see here. Taking a look at the next question. All right, Chazzy's channel asks, if I sell products or do consultations online and I'm only registered in the state I reside in, I'm not, am I not protected in case of a lawsuit? How would I go about protecting myself with an online business? All right. I answered this question earlier, and it relates to whether you need to do a registered agent and a state registration in each state where you're doing business. And I'm going to just refer you to the earlier question. Maybe there's one aspect here that I didn't cover previously, and that's this. If an LLC does business in all 50 states, but does not register in all 50 states, can you as an owner be individually liable for lawsuits in those states? So I talked previously about the fact that if an LLC is operating in states where it has not registered, it might get sued in those states and not know about the lawsuit in those states. And there are some things you can do to minimize that risk, even if you're not going to register as you are legally required to do, because it's quite expensive to register in those states and have a registered agent. So we'll put a link to that if you've missed that video. But the question here is, can you be personally liable as a business owner if your LLC operates in other states without registering in those states? The general answer is no, that you're not personally liable because you are not personally doing business in those states. It's your LLC that's doing business in those states. If your LLC fails to register, the LLC is liable, not you personally. That's usually the case. Now, state legislatures could put into state law that you have personal liability for something. And I don't know the law in all 50 states. For example, I'll tell you in Minnesota, if you don't pay your employees, you can be personally liable as an owner or as the president of the company for not paying wages to your employees. So it is permissible for state laws to put personal liability on an individual who fails to do something for the LLC. But I am not aware of any law in any state at this time that would have a owner personally liable for the LLC's debts or liabilities or other activities merely because the LLC failed to register as doing business in another state. All right, Nesh and Nay have another question. Oh boy. Okay. If you have a judgment against a business that sold the assets, so like the building equipment, etc., and the registered agent of the business has died, can you enforce the judgment on the heirs? All right, so what you have here is a judgment, or you have somebody who sued a business. That business lost the lawsuit, so there's a judgment against it. The business sold the assets, which means presumably that it got money in exchange for those assets. Now, obviously, if that money were sitting in the business, it could be taken by whoever owns the judgment. But let's assume that that money that was received from selling the building equipment, etc., was put in the entity and then paid out as a profit distribution to the owner of the business. or to, if it's an estate, perhaps there were heirs of the estate. The general rule is that a business is not permitted to distribute profits to shareholders if it has debts to creditors. So if there's a judgment against a business, the business needs to either satisfy that judgment with the assets like the equipment or real estate, or with the cash received from selling that. If the money is distributed to shareholders or given to anybody else, that is typically illegal. It is typically not permitted by LLC or corporation statutes to go to the shareholders or the LLC owners. It's not permitted to be a gift to anyone else under fraudulent transfer laws. By the way, I'm not talking about statute of fraud laws here. I'm talking about fraudulent transfer laws. What is that? A fraudulent transfer law basically says if somebody just gives money to someone else to avoid having to give that money up to a creditor, the court can pull back that money or have that judgment added to that other person who got it. So there are statutes of limitations, or there are deadlines in fraudulent transfers laws, so you need to act promptly. But as a general rule, in all 50 states, if you have a judgment against a business and it somehow gets rid of those assets in the business through either a profit distribution or a gift, you would have a right to go after whoever received that under fraudulent transfer laws. Obviously, the business itself has nothing, so a judgment against the business is worthless. But keep in mind, there are short timelines to take action on this. Now let's talk about this issue of if a registered agent of an LLC dies, does that affect the judgment of the business? Here's the scenario. A business has a registered agent. Let's say it's an individual who can receive lawsuit documents for the business, and that registered agent dies. Does that affect a judgment or any legal claims against the business? No, and here's why. A registered agent is merely a person who is authorized by law to receive documents, lawsuit documents, for the company. So if a corporation names Emily as a registered agent, then Emily can receive those lawsuit documents, and the corporation is deemed by law to have received them if Emily received them. That's what a registered agent is. So if Emily passes away, does that mean that the corporation can't be sued? No, because you can still serve the lawsuit documents on the corporation at its registered office. And if it doesn't have a registered office, there's a state process for serving the government with those documents. So in general, a registered agent is an additional person who can be sued and receive documents for a corporation. It's not the only person. The corporation can always receive the documents for itself as well. So the death of a registered agent may reduce the number of people who can receive a lawsuit, but it doesn't affect any delivery of official legal documents, because legal documents can always be served on the corporate office, and there is no effect on a judgment when registered agents change or die, because that judgment remains on the corporate entity. The agent is merely a person who can act on behalf of the corporation to accept the documents. All right. What should business owners be aware of when it comes to employee embezzlement and fraud? How do you prevent theft from within your company? How do you as a business owner guard against one of the big secret legal risks that affect businesses today? Businesses today are quite complex, where it's not paper accounting anymore. It's some sort of financial software. And there are typically different electronic accounts at various banks or financial institutions. There's a lot going on, and business owners need to stay focused on the big things in growing the business. So as a result, they often hire people to handle the financial matters, the smaller matters. And one of the big secrets that I have not seen much attention about is how often internal fraud and embezzlement happens in businesses. I know this because it has happened to my clients, and I've been called in as an attorney to help business owners in dealing with internal embezzlement. Here's why you may not have heard about it though, because businesses don't want to be known as being vulnerable to this. They don't want other employees to know that they were taken advantage of. They don't want customers and vendors and others to know that they were susceptible to internal fraud, that they might have been naive or negligent in some way or not have had proper procedures in place. So usually the business owners keep very confidential if there was any sort of fraud or embezzlement or misappropriation that occurred. When a business owner faces internal embezzlement, typically they call in the professionals, an attorney, an accountant, perhaps others, to figure out what's actually happened here, like track down all the information, and then what are my options for dealing with it. That remains confidential. So, what can you as a business owner do about this? How do you avoid this sort of internal fraud? Well, the best way is to be aware of the types of fraud that occur and the best practices to mitigate those risks in those areas. So, for one example is billing schemes. A billing scheme is when an employee sets up fictitious vendors and then they make payments to those vendors. This would be on the company's payroll. So, for example, an employee might set up a vendor for some office supplies, but this vendor isn't real. And the employee may set up a fake LLC, maybe it's even a real LLC, and just starts making payments to those LLCs and keeps it a really small amount so other people uh, don't worry about it. It's just not enough money to really care. But the employee is essentially pocketing every payment that goes to that fake vendor. So that's billing schemes. The next category of employee fraud or embezzlement is payroll schemes. This is when an employee creates a ghost employee or a fake employee on the payroll, or inflates their hours on the payroll, or manipulates the rate of pay that they should have. I one time had an employee do this. This employee was responsible for everybody's payroll, and we had salaried people and we had hourly people. And the hourly people would report their hours to this employee. The employee would hold them accountable and look out for the best interests of the business. And I approved all salaries in advance, so those all stayed the same. Well, guess what? One time, well, in the payroll system, he gave himself a raise, a 5-figure raise. This was on top of an already 6-figure salary. Um, and I probably would never have realized it except a few months later when I was looking at giving this employee a raise. It was brought to my attention that there was a raise a few months earlier. So, unfortunately, this is a common area of employee fraud, and the best way to guard against this is to have a second set of eyes reviewing everything. Now, although that second person could be in on the scam, it's far less likely that two people will participate in a scam than one. Just statistically, it's less likely. So that certainly can help. Sometimes you have a person that you especially trust looking over things. That might be a family member or somebody you've worked with for a long time, and that rapport and trust has been built. The third common way that employees may try to embezzle in your business is expense reimbursement schemes. This is where they either inflate their expenses for travel or meals or supplies, or they make up fake expenses or submit false receipts or false paperwork. The fifth common way that employees, the fourth common way that employees try to steal from your company is check tampering. This is when the employee writes checks from the company for their own personal gain. They might forge signatures. One best practice is to require 2 signatures on every check of your company. So that at least reduces the odds of one person being able to act alone to participate in a fraud. The next common way that employees cheat their company out of money is skimming. Skimming is when the money coming in each day, like in a cash register, some of it is pulled out and pocketed by the employee. Sometimes this is done with cash. Sometimes it's in a more elaborate scheme. But ultimately, skimming is where the money that's supposed to go to the business gets set aside and pocketed by the employee. Next is theft. Straight out theft. Employees will steal anything from photocopies, paper, office supplies, electronic equipment, toner cartridges, flash drives, hard drives, computer equipment. I have seen all sorts of theft because often these things are not carefully tracked. And within the uh, team of employees, there has to be a degree of trust that people aren't going to take things for their own purposes. And so often, what companies will do is they will have a list of all computers that they have with serial numbers on them and who's been assigned to them. Likewise, any other important equipment. And then there might be cameras or something else monitoring copy machine rooms or uh, rooms where inventory is kept, so that if somebody is stealing something and there's a question about it later, because typically you don't know at the time, but if there's a question about it later, at least there may be some footage or some sort of video or record of the theft that occurred. The next common way employees take from business owners is fraudulent financial reporting. This is where the employees manipulate financial records to hide what they've done or to make the company seem more profitable than it actually was, or make it look like it met certain financial targets that it didn't. I had an employee who managed the expenses of the company. And what he would do is we were at cash basis accounting. And so whatever cash we had, it looked like that was profit. But what he would do is he would slowly pay the vendors. So instead of paying 2 weeks after the bill comes, he would pay 90 days after the bill comes. So what that effectively did is it allowed us to keep a lot more money, at least for 90 days. So instead of that 90 days worth of expenses having been paid out to the vendors who it belonged to, it was at least temporarily sitting in our accounts. And this was a rolling 90 days. So we always had more. We had 90 days more of money in our accounts. It made us look like we were doing much better. And so a person in management can basically say, hey, look at all the money we have. Wow, we're doing great. A lot more money than we had before I came. This is incredible. When in fact, it's slow paying of the vendors or manipulating reports. 8. The 8th way that employees can steal from your company is kickback schemes. So the employee might agree to buy a certain amount of inventory from a legitimate vendor of yours, let's say $40,000 worth of inventory, but the employee has a deal with the vendor that in exchange, he gets $2,000 worth of gift cards. Well, those gift cards, he justifies it by saying, oh, it's not money, but essentially it is. I mean, you can sell gift cards and get money. And those gift cards should have gone to the business, if anyone, not the employee personally. And so kickbacks are largely illegal. In fact, they are always illegal because they're a breach of fiduciary duty. So that it is always illegal for an employee to do it. It's illegal for a company to participate in kickbacks because they are tortiously interfering with the fiduciary duty of an employee to the company. And there are specific industries where kickbacks are flat out and directly banned. And they can actually be criminal. But kickback schemes, whether it be gift cards or baseball games or other dinners out or whatever those perks may be, the employees may be benefiting from the vendors because the employees have the authority to control which vendors are used and which transactions the company is engaged in. So it's important to have policies against this, as well as put the vendors on notice that they'll have liability if they participate in any kickback schemes. Often companies will require vendors to agree to that they will not engage in any kickback schemes or benefits to the employees as a condition of doing business with the company. The final common way of employee theft is employees stealing data. Employees can sell that to competitors. The employees can sell data for fraudulent purposes, but data has significant value in a company. And often that data can just be copied and you don't know it's missing. So having controls on what data each type of employee has access to can be very valuable, especially as you grow. For example, the marketing employees don't need access to the financial records of the company. Similarly, the financial, or let's put it, the accounting department doesn't need the customer database or the prospect database. All this data should be on a need-to-use basis, and that can be partitioned as companies grow and they add more employees. It's very important to limit what data employees have access to based on what they need. This is a summary of common ways that employees can steal from you as a business owner and steal from your company. And I'm presenting this knowing there's some risk that employees might watch this and learn from this, but this stuff is already out there. And I am doing it on this channel for you as business owners, so you can make sure in your company, at a minimum, you've thought about the risk and decided to accept it, or even better, you've implemented some sort of procedure to minimize the risk that employees can steal from you or devalue your business. This happens all the time. Some reports indicate 90% or 100% of companies suffer from the consequences of employee theft. Of course, it's not often detected, and it's usually only the huge situations where companies finally realize, hey, we're missing hundreds of thousands of dollars. What's happened here? Often by that time, it can be too late. All right, I am going to wrap up here. I'm Aaron Hall. I'm an attorney for business owners and entrepreneurs. I do this educational channel to help you spot issues to discuss with your attorney, to help you identify ways to avoid problems. But keep in mind, it's an educational channel. This is not a replacement for using an attorney who understands the law in your state, in your jurisdiction, and can take the time to understand your particular goals and concerns and exceptions that might apply to you. I'd love for you to get the exclusive free resource that we make available to subscribers. It's a list of common legal problems and how to avoid them, and then videos, educational videos talking about how to avoid those problems in your company and set your company up for success. You can get that at aaronhall.com/free. Enter your email address, and we will start sending you that information by email. If you have other questions, feel free to continue to add them here. I will use those questions to answer in a future live Q&A. It was great being with you today. I look forward to seeing you again on the next live session.